afternoon, Mr. and Miss Brisker. Thanks so much for coming into our office today. My name is Svetlana and these are my colleagues, John and Craig. AJ has kindly referred your matter to us. We've got a few topics to go over, so if you've got any questions throughout, feel free to just jump in and ask. I'll be briefing you on the cooling off period and going over the legislation surrounding misleading or deceptive conduct. John will be overseeing the seller warranties and also your rights for termination in relation to encumbrances, and Craig will be going over the statutory warranties and any latent or patent defects in the property. Now, as per your contract, you've got a 5 business day calling off period which ends at 5 p.m. on the 27th of August. This means that you're able to cancel at any time prior to that cutoff, so long as you provide a written notice signed by both of you. This can be done via email, fax, or even in person. The only downside is that you'll lose 0.25% of your deposit, which, Bert, I'm sure your accountant brain will know that that's a $5,000 deduction from your initial $95,000 deposit. Otherwise, you're within your legal right to terminate on the grounds of misleading or deceptive conduct. The manner in which real estate agents and other such marketeers can conduct themselves is actually legislated by the Property Occupations Act, which is very clear in that they must avoid engaging in any conduct which is even slightly likely to mislead or deceive the purchaser. We've noticed several instances of deception after viewing the body corporate minutes. For starters, you made it very clear to the realtor that you weren't interested in a place with noise or short-term visitors. Within the minutes, however, it's noted that although there isn't a specific mention of noise, there have been several complaints over the course of 2 years surrounding objectionable parties and drunken behavior. Now, I'm sure as all of us here know, any reasonable person could assume that there must be at least a modicum of noticeable and consistent noise for such complaints to be made so consistently, especially over the course of 2 years. Equally, there have been several court cases which actually note that silence can also be taken as misleading or deceptive conduct. So even though the agent neglected to comment on your statements about the short-term guests, given the context, one would assume that no comment equates to an implication that there aren't short-term guests, which of course is misleading in its nature. Furthermore, I've perused the body corporate disclosure notice that you were provided by the realtor, and I noticed that it only makes note of the current works, which is covered by the sinking fund of $1,306. However, the body corporate minutes brought to light some pressing maintenance items which would actually financially impact you both to a very notable extent. You'd be paying a shocking total of $37,254.06 in special levies on top of your original levies over the course of 12 months. Due to all of these misleading and deceptive tactics, you're well within your rights to terminate under Schedule 2 of the Competition and Consumer Act if you so choose, as opposed to terminating within the cooling off period and forfeiting that $5,000. Did you have any questions? No? All right, perfect. I'll hand you over to John then.
Okay, thanks, Lavada. I'm John. I'm going to briefly talk about clauses 7.2 regarding encumbrances and then what the warranties are. So an encumbrance is any defect on either the property or the title of the property. And the first thing is that there's some illegibility issues with the written instrument with respect to the easement. Now, that in and of itself is not necessarily a deal-breaking issue, but it gives us an opportunity to delay settlement if we need to buy some time, as it were, to pursue other matters. Of 5 instances of the easement registration being mentioned, it's written 3 different ways. So, or at least it can be construed 3 different ways as per the copy we have. The other encumbrances are, of course, that the building needs to be sound, as Slaver has mentioned, there's concrete cancer, there's balustrades, there's pine trees that require work, there's the revetment wall. But legally, in addition to that, one of the sellers is not actually on the title. Now, I'll speak more to that when it comes to the warranty. So if we go into warranties, I just want to give you a different idea of what warranty is used in legal terms. It's actually defined in law as an assurance that certain facts are as they are represented, meaning that when there's a warrant as a component of a condition of a contract, that is binding. Well, in the absence of telling us that there's concrete cancer, etc., there's an issue with the contract. Now, the main issue under the warrants is 743A, that the seller is not capable of selling this property to you. Let me explain to you how that works. With a different sort of a story. Say there's a married couple and the husband comes home drunk and the wife says, well, I've had enough of this nonsense. So I'm going to go and see my sister. Drives off to see her sister. And while she's away, the husband, enraged, calls the cops and says, this car's been stolen, pull it over. The cops pull her up when she's halfway to her sister and say, right, we're going to arrest you for stealing this car. And she laughs and says, dear Mr. Policeman, here's my ownership documents on the registration. I'm the only person who owns this car. Here's my driver's license that matches the ownership documents that says, this is who I am. Policeman says, oh, well, you can't steal what you own. Have a good evening. Drives on to his sister's place. Just as you can't steal what you already own, you cannot sell what you don't own. Well, we have Mr. Guthrie on the contract who does not own the property because he's not on the register of ownership. He can't sell it. QED, the contract is null and void. Really simple. Nothing to worry about. Let us put your mind at ease that you've got multiple grounds on which you can walk away from this. I'm going to give a little bit more time to Craig so he can sum up for the whole group. So I'll say thank you to Slavata and I'll pass over to Craig.
Thank you, John.
Thank you, Craig.
Good afternoon, Mr. and Mrs. Briscoe. By way of introduction, my name is Craig and I'm one of the solicitors here at the Property Group section. I want to take a few minutes to go over some important warranty matters regarding your recent interest in the property at the Broadwater Leas complex. We have identified some issues that could significantly impact your decision to proceed with this purchase. Importantly, we want to ensure you both are fully informed before making any decisions. First, let's talk about the warranties the seller must uphold under this contract. The contract's warranty is broken down into several components, which I will outline for you now. The first warranty looks at enforcement notices. This is where the local government believes that the building structure is unfit for occupation or has serious defects. When this occurs, they issue an enforcement notice to the owner. Now, the seller is required by law to disclose any outstanding notices from the Gold Coast City Council. Because there is no formal notices, it seems that the seller hasn't breached their warranty under this clause on your contract. Next is legal claims and proceedings. This warranty provides that the seller informs you of any ongoing or threatened legal proceedings that could impact your property. This property is, or in particular warranty, is to protect you from any unexpected legal complications that may occur. The good news is that there is no current legal disputes involving this property. However, while some issues have been reported about the disruptive noise from the short-term renters, it hasn't escalated into legal action. So at this stage, it appears the seller has not breached this clause either. Finally, the seller must ensure that the property is not subject to notifiable activities or classified as contaminated under the Environmental Protection Act. While there are some concerns regarding the revetment wall and its potential impact on the environment, there's no direct evidence of contamination on the property. This means there doesn't seem to be any breach on environmental warranties, but future maintenance will need to be managed carefully to prevent any issues. Now let's shift to the statutory warranties, which primarily deal with the body corporate. Now when looking at the property defects, the seller must disclose any latent or patent defects in the common property. Significant issues like the compromised revetment wall or the non-compliant balustrades should have been disclosed in the contract. Failure to disclose those could potentially breach statutory warranties, therefore giving you grounds to terminate the contract. With regard to liabilities and financial concerns, the seller must also disclose any actual, contingent, or expected liabilities, like the special levy for maintenance. This is a significant amount, and not disclosing it is particularly concerning. It could also be considered a breach of warranty, further strengthening your position if you choose to terminate the contract. Given these findings, I'll go through some recommendations for you to consider. Firstly, the cooling off period expires at 5 p.m. on August 27th. If you terminate within this period, you can do so with a financial penalty of $5,000, which is 0.25% of your selling price. Terminating the contract now would allow you to avoid potential future complications and financial losses associated with these undisclosed issues. Alternatively, you can look at the seller's failure to disclose critical issues, including the special levy, the true extent of the maintenance issues, and the impact of the short-term rentals, which might constitute significant breaches of statutory warranties and possibly even misleading conduct under the Australian consumer law. In summary, you have a strong case for terminating the contract based on the statutory breaches and the misrepresentations regarding the property's condition. If you're inclined to move forward with termination, we can draft a letter of advice for you, citing the breaches and recommendations for you in this matter. If you choose to utilise the cooling off period, then we'll need to notify the seller's agent before 5 p.m. tomorrow. But before we discuss any questions or concerns you might have, if you choose Perfect Property Law to represent you in this matter, you must discuss the cost agreement and provide you with a disclosure notice and cyber alert documentation before taking on this matter on your behalf. Do you have any questions for us? Thank you.